Good morning, everyone. In this contribution LPs, the below review, I will discuss the notion of constitutional identity within the broader framework of the relationship between legal orders. So let's begin. The question of the strengths and weaknesses of law goes to the very heart of how legal systems are built. Law is generally understood not only as a tool for organizing society, but also as an instrument we turn to when we need solutions to the problems we identify. So each time we mobilize legal mechanisms, two questions inevitably arise. First, is the law the right instrument to resolve the conflicts at hand? And second, once it has been applied, how effective has it actually been? Put differently, does the law genuinely produce the outcomes we expect? And what does that reveal about its traits and its limits? I want to look at this question through the lens of the relationship between the legal orders of the EU member states and that of the European Union. One of the major fault lines, one that has shaped these relations for decades and continues to do so, lies in the difficulty of reconciling, on the one side, the Union's foundational principles such as primacy and direct effect, and on the other side, the supremacy of the member states' national constitutions. This issue, well known to legal experts specializing in European law, has experienced several moments of tension, which have, in a certain way, contributed to advancing European integration. An emblematic example is the one related to the protection of fundamental rights within the legal order of the European communities. This debate emerged under the influence of the German and Italian constitutional courts, which believed that community law did not sufficiently guarantee fundamental rights in comparison to their national constitutions, notably the Solange-Heinz jurisprudence and the Frontini and Pozzani decisions regarding counterlimits. This concern gave rise to a conflict between community law and national constitutional rights. In response, the Court of Justice of the European Communities issued a series of rulings: the Stauder judgment in 1969, the Internationale Handelsgesellschaft judgment in 1970, the Nord judgment in 1974, and the Rutilli judgment in 1975. Through these rulings, the Court of Justice was able to integrate the protection of fundamental rights into the community legal order by linking them to the general principles of community law. This solution, resulting from the case law interpretation of the Court of Justice of the European Communities, helped to ease part of the conflict. This tension, which sometimes leads to open conflict, stems from two parallel developments. Okay, so the first development is the growth of European integration itself. Through the familiar spillover dynamic, the scope of EU law gradually expanded and eventually reached areas that directly touch on constitutional questions. The second development is the rise of 20th century European constitutionalism. During this period, member states increasingly embraced constitutional review mechanisms and strengthened their commitment to the rule of law. This evolution led to a steady consolidation of constitutional principles at national level, continuously broadening the reach of domestic constitutional law. Taken together, European integration and the strengthening of national constitutionalism have created a legal environment in which EU norms and constitutional norms now intersect and sometimes collide far more frequently. This interaction, smooth at times and conflictual at others, has become a structural hallmark of today's European legal landscape. And even though tools exist to foster coordination, particularly the preliminary ruling procedure before the Court of Justice, the absence of any prior systematic framework has produced what sometimes feels like a conceptual dead end, almost an ontological tension in the way we think about the relationship between national legal orders and the EU legal order. This picture, however, requires nuance, because not all member states have experienced these tensions in the same way. Some have adopted a more flexible approach, while others have constitutions sometimes described as European-minded. In other words, conflicts depend heavily on each state's constitutional culture and on how it understands the primacy of EU law. At the judicial level, the complexity of this interaction has often prompted courts to steer away from direct confrontation. Many have adopted strategic or diplomatic approaches in order to avoid open constitutional conflict, by invoking ideas such as relative or absolute primacy, by relying on translation or reinterpretation techniques, or by seeking some form of equivalent protection. But over time, this fragile equilibrium has come to appear increasingly limited. That is why certain national tribunals have eventually chosen to adopt more assertive positions. And it is precisely at this moment that the question of the strengths and weaknesses of law re-emerges. One of the most significant responses to these tensions has come directly from case law, the emergence of the concept of constitutional identity. The rise of national constitutional identity has become one of the clearest examples of a doctrinal device developed to set limits on the reach of external law. Over time, this notion has taken shape within the broader family of counter-limits elaborated by several Supreme and Constitutional Courts. Initially mentioned only sporadically in isolated constitutional decisions, it gradually came to be framed as a limit that member states may invoke against obligations stemming from their participation in the European Union. Notable examples include decisions of the Austrian Constitutional Court, the Latvian Constitutional Court, the German Federal Constitutional Court, the French Constitutional Council, the Czech Constitutional Court, as well as ruling from the Polish Constitutional Court and the Hungarian Constitutional Court, among others. Taken together, these rulings show how the concept has spread and become embedded in the reasoning of multiple national courts. Constitutional identity has thus found its place within the architecture of relations between legal orders and has become a key lens through which those relations are interpreted. This development builds in part on a strategic reading of Article 4 TEU, which requires the Union to respect the national identities of the member states. National courts have effectively added a national layer to this wording, even though national identity and constitutional identity are far from synonymous. And this is precisely where the ambivalence of the notion becomes most visible. What might initially have appeared to be a promising legal tool, a device capable of supporting a balanced resolution of conflicts, reveals on closer examination both its strengths and its vulnerabilities. On the straight side, it is important to recall from the outset that constitutional identity is a judicial construct deliberately designed to structure and regulate the relationship between legal orders. It is a functional notion. Its primary purpose is protective, and it is meant to be invoked only when circumstances genuinely require it. In this sense, the notion carves out a space for conciliation, a space in which the obligations arising from EU membership can be reconciled with the constitutional particularities of each member state. And yet, the notion carries a striking paradox. It has never been formally defined. The very language used to articulate this counter limit is inherently vague, so vague that, as a well-known line puts it, scholars have been left to speculate about a shadow. Many have pointed out that no authoritative definitions exist. Legislators have now attempted one. Courts have avoided it, and scholars have never reached consensus. The content of constitutional identity is therefore, by its very nature, impossible to determine in advance. This indeterminacy makes it difficult to anticipate which situation might be seen as violations, and it complicates any effort to prevent conflicts before they materialize. But why is the notion deliberately left so open? Because a state's constitutional identity only truly comes into focus when it is perceived as under threat. In this logic, only member states, through their constitutional authorities, are competent to decide what they consider to be part of their constitutional identity. Any attempt to identify abstractly and ahead of time which principles or provisions belong to that identity would be illusory. Moreover, trying to define constitutional identity with precision would not only be unnecessary, it would run counter to what the notion is meant to achieve. Its indeterminacy is, in fact, essential. It gives the concept the flexibility needed for it to be activated when circumstances call for it. As I have already emphasized, this is a functional tool, and its usefulness lies precisely in its capacity to respond to unpredictable situations. And, as with any vague legal concept, the more open it is, the more room it leaves for those who invoke it, and for the authorities tasked with giving it concrete meaning. Both the signifier and the signified become instruments in the hands of those relying on them. It is true that in some countries, most notably Germany, the Constitutional Court has attempted to provide clarifications. But even then, the vagueness cannot be fully removed. Even if the constituent power or a constitutional court were to draw up a list of principles said to form part of constitutional identity, nothing guarantees that it is the principles themselves that embody the identity rather than the specific interpretation given to them. In the end, constitutional identity must be understood as a functional notion rather than a material one. So its vagueness, its very ambiguity, is deliberately preserved to ensure the flexibility required for it to be deployed when the moment demands it. On the weakness side, the very indeterminacy that gives constitutional identity its functional traits is also what exposes its main structural limits. For clarity, I'll focus on just two difficulties here, though of course many more examples could be given. First, because the notion is inherently open-handed, it's impossible to anticipate in advance the situations in which it might be invoked. Any attempt to define its content beforehand would strip it of its very purpose. But the consequence is clear. National courts enjoy a very wide margin of discretion. As Advocate General Pedro Cruz Villalón warned in Gauweiler, allowing each member state to rely on an almost unlimited identity reservation risks reducing EU law to a kind of residual legal order. Second, this vagueness gives political actors considerable room to maneuver. A notion originally conceived as a purely judicial counterlimit can, in practice, slip out of the judge's hand. We have seen governments invoke constitutional identity before the Court of Justice, even when their own constitutional court has never recognized the concept. The case Commission versus Luxembourg is an especially clear example. The Luxembourg government tried to justify a nationality requirement for notaries by appealing to its constitutional identity, despite the fact that the country's constitutional case law has never referred to such a notion. At the domestic level, political appropriation takes other forms as well. Some governments have been considered constitutionalizing the notion, Hungary being the most striking example. And in France, a specific pattern stands out. Members of parliament sometimes invoke constitutional identity by giving it a completely autonomous meaning unsupported by any case law in order to refer a statute to the Constitutional Council during a priori constitutional review. Their aim is to obtain a declaration of unconstitutionality before the law is promulgated. All of this shows how a tool originally crafted by judges can be reframed, stretched, or even distorted once it enters the political arena. So, ultimately, when we think of law as an instrument for resolving conflict, we return to a persistent tension. Law aims to provide solution and ensure effectiveness, but doing so constantly requires us to reassess the overall balance of the system.